All right, guys, we have really big news. Coinbase's legal guy pointed out that Gary Gensler might have, whoops, I did it again. I screwed up again. And this might actually make him lose all the cases because he did not follow due process, and the judge could slam him for that. This could definitely hurt him in the debt box case, but also against Coinbase, Binance, Robinhood, Ripple, and all the others. I mean, they've already kind of lost the case against Ripple at this point, but this could force them to lose the case against pretty much everyone else. Let's take a closer look. This time, the pain is self-inflicted because the SEC actually made an admission that it did not follow due process, which, as all of you know, is very, very important for our legal system. And they did it in the debt box case, but it could possibly flow over to all the other cases. So basically, the debt box case is back in focus. Of course, he zeroed in on one statement, and this could actually have big conclusions. So the thing is, like, the case has seen the federal agency slammed and sanctioned by U.S. District Judge Robert Shelby. Now, let's remember, this is the case where the SEC lawyers actually got sanctioned because they made materially false and misleading representations. Like, the SEC's like, our lawyers should not get sanctioned. The judge is like, nah, I don't think so. I'm going to sanction your lawyers because they suck. In attempts to prove its case that the firm defrauded investors of over $50 million. At the same time, the agency's efforts to dismiss the case without prejudice, which means they could actually sue them again, failed, and now Deadbox is trying to dismiss it with prejudice. So essentially, there was one line that Coinbase's CLO, Chief Legal Officer, said. He alleges that the statement suggests that the agency has failed to follow due process, Fifth Amendment, in its enforcement actions against crypto firms, and it's attempting to lie about it. Obviously, we've known this for a long time, but if you can legally prove it, it could shut down their case. Is the SEC failing to follow due process in crypto enforcement actions? Responding to a debt box claim that the SEC must provide its entire investigative file to parties when it provides a Wells notice, the agency in its Monday filing asserted that its staff typically provides a thorough explanation of the evidence used to prove potential charges against an entity. However, according to this Coinbase CLO, there was an admission of that was not the case with Coinbase. We received no thorough explanation, and the SEC, for its part, did not actually provide Coinbase with much of the evidence, because they didn't really have any, of what assets, which they couldn't name, supposedly gave rise to securities transactions. We weren't told what assets were at issue at all. So the thing is, if you don't do that, you don't really have much of a case, because you do need to explain to people what assets are causing the problem and what transactions are causing the problem. Why would the government not follow its typical process in our case? And what does that say about its claims? Which means they don't have a claim. So essentially they're going to claim, so like all these cases can claim the SEC is not following due process. So he later explained that this wasn't actually limited to Coinbase alone, and he tagged several other crypto firms. So he's asking, Robinhood, did you get an explanation? What about Ripple, Uniswap, Kraken FX, Binance US, anyone else? My guess is if the SEC flubbed the explanation on Coinbase, they probably flubbed the explanation to everyone else as well. And this is maybe a pivotal mistake in the SEC's case. According to Fagel, the information shared in a Wells notice depends on the case and who handles it. Typically is doing a lot of work for the SEC here. There is a wide range of practices regarding how much or how little information to share with proposed defendants during Wells discussions, depending on the nature of the case and, unfortunately, on the particular SEC staff. And this is a response to Greenwald. But the thing is, like, it's hard to sue someone when you don't really put the case against them. And there is due process. So you have to at least tell them which cryptos are actually in question here, which ones are securities, and what transactions they constitute, because that's the actual crime. If you don't tell them the actual crime, you can't really sue someone in the United States. Maybe the government can, but I know like regular people can't sue other people if they don't tell them what exactly they're suing them for. So, responding to whether Greenwald's observations could be used against the SEC, he noted that they were irrelevant to the case. It's irrelevant to the lawsuit. There's no legal requirement for the SEC to share a particular amount of information, or any for that matter, with the defendant before filing suit. But when you file the suit, you kind of have to tell them what you're actually filing for. And I think this could actually be used against them. I think the judge is already using this against the SEC, mainly because like they've repeatedly said the SEC has failed to actually bring up particular instances, and that's probably true for every single case. I do actually think that the Fagel guy is essentially like trying just to pass this down, but I do think there is a problem with this because like they never really told him like which coins or made a statement on which coins they're actually suing them for. They gave him like a list sort of, but they also didn't tell him which transactions they're suing them for. And this has really hurt them in DebtBox, and I think it'll hurt them in the Coinbase lawsuit as well, even though Coinbase did fail to toss the SEC lawsuit. Why this matters: despite calls for regulatory clarity, the SEC has continued to carry out enforcement actions against crypto firms, asserting that traditional securities laws are sufficient to guide the industry, but there hasn't been a ruling that cryptos are securities. So that's another issue altogether. This approach has led to many to believe that the regulator is not acting in good faith because you can't really assume something is a security when it's not specifically said so. And the SEC is not the one that makes the law, but they are the one that kind of just enforces it. If the law's not there, it's hard for them to enforce. So as you can see, this could be a critical mistake for the SEC, or like one that they made on purpose that they don't really want to deal with. And it could actually, I think, be used against them, especially with particular judges that are tired of the SEC's overextension. Even though Coinbase did not get the lawsuit dismissed, I don't think they're going to lose the lawsuit, especially with the Ripple win, and especially because other lawsuits aren't going in the SEC's favor. And this insistence of the SEC to not basically tell them which transaction they're suing them for and what exactly they're suing them for. Like, they're just like, you violated securities laws, but they didn't really tell them like where exactly they violated securities laws. I think that's going to hurt the agency. So that's the news for today. Let me know what you think. Like and subscribe, hit that bell notifications button. Thank you and have a nice day.